turn to a very special guest, President Donald Trump's personal attorney, Jay Sekulow, who joins me on a newsworthy night on the beat. Good evening. Thanks for coming on the show.
Thanks for having me, Ari. I appreciate it.
Your view of what Bob Mueller found regarding no chargeable collusion.
Well, I'm going to say, before we get to the no chargeable collusion, I watched former Attorney General Holder and Mr. Rossi, your last guest, and you've conflated the independent counsel statute, which is what Leon Jaworski and Starr were operating under. And
here's what I'm going to do. I'm going to let us get into obstruction. I wanted to begin with something that I thought you'd be very interested in, which is I want to make sure that
I want to set the record straight.
Because let me promise you this. I will reserve time for you to address anything you want to say about that.
Great.
But as the moderator, I'm going to begin with something I thought you might want to even talk about, but that I've posed as the first question, and I will save time for that rebuttal to Mr. Holder. I promise you. Now,
thank you.
Walk us through your view of no chargeable collusion, sir.
Well, I mean, it's very clear. The position that we've advocated since the beginning, and that's clear in what has been released, is that there was no collusion. There was no evidence of collusion, and there was no evidence of anybody associated with the Trump campaign engaged in collusion with the Russian government or people affiliated with the Russians. That was crystal clear. So that was the basis, by the way, Ari, you know this, that was the basis upon which this investigation started, was this whole collusion issue. What was the Russian engagement or lack of engagement during this campaign cycle, and specifically as it related to the president and the president's campaign, and the special counsel said there was none.
And so on that, given that that would be, by most accounts, good news for your client, President Trump, how do you explain how many misstatements and falsehoods there were? Other people, as you know, were convicted of obstruction-related crimes and lying to the feds. That's not in doubt. How do you explain all of that now that you have this result that would seem to be positive on the lack of conspiracy?
Well, that individuals that were charged or pled or were convicted were charged with crimes unrelated to the issue of collusion with Russia. Most of the charges were what's called process crimes. That was lying to federal officers, tax evasion, FARA violations. So those are very different. There was no charges. Interestingly, if you look at all of the indictments that have issued here, there were no indictments that made an allegation of collusion with the Russians or Russian government officials. So I think that the indictments spoke for themselves in that sense. And apparently, and we haven't seen the report, obviously, we've seen what what's been put forward in the summary letter that the Attorney General issued, that there was no collusion. And that's crystal clear.
Now, you wanted to get into the obstruction part of the discussion, including what Attorney General Holder, former Attorney General, said. Let me play some of Attorney General Holder and get your response. We're going to get this clip of it, because basically one of the most interesting things that the Attorney General said, which relates not only to your client, the President of the United States, but relates to who should be the decision maker on issues of obstruction, is whether that's something that the Attorney General handles or the Congress. Take a look.
He's certainly departing from those precedents, and I would say he's acting in a way that's inconsistent with the best practice. It would seem to me that having received the information in the way that he did from Bob Mueller, that Attorney General Barr should have taken that information and then, packaged it in the appropriate form and sent it to the House for consideration.
Do you dispute that that is how obstruction issues were dealt with in both the Clinton and Nixon precedents?
Yeah, no, I don't dispute that's how they were dealt with in the Nixon and in the situation with President Clinton. But what the Attorney General and Mr. Rossi failed to recognize is that those investigations operated under an independent counsel statute, Ari, that is markedly different than that law sunset. Bipartisan. Republicans and Democrats did not want that law to continue after the investigation of President Clinton. So what replaced it was a special counsel regulation. And the difference between Leon Jaworski and Ken Starr was they reported to judges and panels. Here you have an interdepartmental Department of Justice situation. The special counsel is not an entity unto himself. The special counsel reports to the Attorney General of the United States. That's different. And then there's a specific regulation that governs what confidential report is delivered not to the United States Congress, but a report that first goes from the special counsel to the Attorney General, and the Attorney General then makes a determination pursuant to the regulations as to what should be released to the United States Congress. I also think it's not right, you give me the opportunity, I appreciate it, to criticize both Bob Mueller and the Attorney General for what they wrote when we haven't seen the report. So everybody's jumping.
Partly,
I mean, you got to give Bill Barr credit. He received the report on a Friday and returned something to the public, what were called principal conclusions, in 48 hours. Now,
so
everybody moves off the narrative.
Jay.
You move off the narrative
let's
of collusion.
Take both pieces.
Go ahead.
And if you've seen the beat, you know we will deal fairly and you will get time. You've raised 2 points here. One, your rebuttal to Holder and others about the historical record, and two,
nothing personal.
Barr's
It's just what the law
I
is.
got you.
Yeah.
Not personal. So let's take each of them. First, on the historical precedent, you are alluding to the fact that there is a different governing authority here.
Which you know, right?
Which I know, yes.
Right. And the reporting authority is different.
Jay, I know we're both lawyers. I'm going to finish the question, and then I'm going to let you answer, all right? So, given that different historical precedent, though, are you suggesting that obstruction by a president, any president, is no longer the province of the House Judiciary Committee? I mean, the Constitution did not sunset along with that federal law.
No, you're conflating two separate issues. You asked me if the reporting process, and your previous guest said that the Attorney General, in essence, was derelict in his duties by engaging in what the statute demands, and that is a confidential report initially between the special counsel and the Attorney General. You then take the issue of obstruction, which, by the way, if you read what Bill Barr wrote in his letter, what did the special counsel say? I don't think this is any great, mystery. None of us have seen the report. But what does he actually say? He said that these issue of obstruction presented difficult questions of law and fact. Well, if you have a difficult question of law and fact, he didn't say the president violated the law. In fact, he said the opposite. There's no statement about violating the law. He said it's not an exoneration, which, by the way, they don't exonerate. As you know, a prosecutor either makes a case or does not. So what you have then is a review.
If we're going to quote the letter, you're quoting Barr, quoting Mueller. He says, quote, difficult issues. That's the sentence, difficult issues. We don't know what else was around the sentence. I take it, as of this hour, you, as the defense attorney for the president, have not seen the Mueller report. Neither have I, and neither have most people other than Barr and a few DOJ folks. So let's get it on record here before I turn to Senator Cory Booker, who's on the Judiciary Committee, and other guests in the show. Let's get it on record. What does no exoneration on obstruction mean to you?
It means that what does no crime mean also? They could be special counsel.
I don't know. When you say no, I don't know what you mean. It says no exoneration, and I'm giving you a chance to say, what does that mean to you?
Ari, read the whole sentence. What does the whole sentence say? What does it say right before no exoneration? Read the sentence.
We can put the whole thing on the screen if you want.
Let's do it.
Let's do it. While this report does not conclude that the president committed a crime, it also does not exonerate him. Yes, sir.
Right.
So what does not exonerate mean to you?
They didn't make a determination. That's all it means. They did not find the president committed a crime. They did not make a determination. What did they do? They either, for whatever reason they had internally, they had a discussion. They decided that it was not going to move forward as a crime. And it says, while this report does not conclude the president engaged a crime, it doesn't exonerate. Now, the exoneration is interesting.
Because let me push you a little bit on this, and I'll give you a chance to respond.
Sure. Absolutely.
Because as you and I know, and as we've reported, so viewers know, the standing policy of the Justice Department under administrations in both parties is not to indict a sitting president.
But hold it. No, Ari, that's not fair because Bill Barr said
I'm going to let you respond. Let's keep this pleasant.
Go ahead. Your show.
I'm going to finish, and then you get to respond.
Your show.
So given that, is your view that Mueller should have given a recommendation if it was for potential obstruction, and you don't indict? Doesn't that go back to the Congress?
Ari, you read what the Attorney General wrote. He said the determination was not based on the existing Department of Justice policies regarding what issue? The issue of you can't indict a sitting president.
Barr's view, not Mueller's. Barr's view. You're referring to footnote 2.
Here's what you got to remember. Barr is the Attorney General of the United States.
Yes,
the Deputy Attorney General of the United States, hold it. The Deputy Attorney General of the United States is Rod Rosenstein. The Office of Legal Counsel is part of the Department of Justice, and Bob Mueller is part of that same department. So they did not determine that there was a crime committed, nor would they, quote, as you said, exonerate. What does that mean? They could not make a determination. That's what it means. But what then happens? It then goes to the Department of Justice for review under the regulations, and that's the decision they made.
Well, let me put it very simple, because
in accordance with the law.
There's things we both don't know. Let me put it very simple. I'm not trying to get you, Jay. I think you've got
But you really are. But Ari, listen, with due respect, and I do watch your show, you are conflating. You conflated the independent counsel with the special counsel, and then you conveniently leave off where it says the president. We're not accusing the president of a crime. A minor thing you leave off.
Jay, save the media criticism for when we're not doing the interview.
No, this isn't media criticism. This is you asked me a question. I'm asking you one.
You want to get into it, and you can tell the president this. The full screen up on the screen that we prepared for this interview has the entire quote. So what you just said was inaccurate, and I'll leave it at that. I'm not going to do a Trump media debate with you, Jay.
Play the tape back where you did not say, where you only said did not exonerate, and you didn't say not the president not guilty of a crime.
Because I'm asking, I've been reporting that all weekend, sir. I've got it back up on the screen. I'm not doing that to undercut you. It's just the fact is we have the entire quote. We deal with context here. Now, Jay, before I let you go, and viewers might wonder why you aren't more excited about the good part of this, which is
I'm excited about all, but I think it was a great day for the president, a great day for the country.
Right. So before I let you go and I turn to Senator Booker, let me ask you this final thought, which is, why do you think that Barr felt the need to go farther than Mueller on the obstruction issues? Why not leave it the way it is? Notify Congress under, as you say, the DOJ rules written by Neil Kochel that are different than the underlying federal statutes that used to exist. Why did Barr go further? It was good for your client, Donald Trump, but was it necessary if the Mueller report left it good enough?
But that's, again, Ari, with due respect. You are conflating independent counsels with special counsel. Bob Mueller works for the Department of Justice. He doesn't report to a 3-judge panel. It's a completely different system. It was eliminated, the independent counsel statute, and Ken Starr was under it and said it should have been eliminated.
Barr didn't have to go further.
When Attorney General Barr did, in conjunction with
this extra letter, you would acknowledge that.
In conjunction with the Office of Legal Counsel and the Deputy Attorney General, do what the Attorney General of the United States is supposed to do as far as an interpretation of the law or a theory of a case. That's it.
Well,
it's actually that simple.
I will say this. While you and I may disagree about your assessment of the beat or how much conflation is going on in my mind, I appreciate on a big news night, I appreciate you coming on the beat.
Thanks.
We gave the Attorney General, Eric Holder, his view. We give you your time, and I really appreciate it.
Appreciate it, Ari. Thank you.
Jay Sekulow, lawyer for the President of the United States. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.